All righty. Welcome to the consultation. My name is Christina Jimenez.
And I'm Josh Floyd.
And we are both family law attorneys in the state of Texas. We practice primarily over in West Texas and in the Metroplex. And every Friday at noon, we get together. Sometimes it's just Floyd and myself. Other times it is other members of our team and other attorneys outside of our office. And we take the time to kind of talk through complex legal issues and just give our opinion and what we think the judges are going to do and what we would do and how we would handle cases. We do answer questions while we're on Facebook Live. And so what I would like to remind everybody of is that this is not to be construed as legal advice. All right. So you'll see as we're going through these fact patterns that there are a lot of nuances that go into the facts. And if this one little thing changed, then it would change the trajectory of the entire case. And so make sure that if ever you find yourself in this particular situation, that you reach out to your own family law attorney, preferably in the county where you reside, that has experience with your particular judge. Because I think I know that is going to be in your best interest. And that's the advice that you should be listening to, because we are not proffering any legal advice. Also, just a friendly reminder, please follow us on all of the social media platforms. We have Twitter, Facebook, LinkedIn, Instagram, TikTok, everything. So if you could follow us, like and follow, that would be wonderful. And with that, Floyd, take us away. I don't think that we can do the first question.
Dang it, I was going to ask you that question. I was really looking forward to that.
You had a big smile on your face. You were ready.
I was real excited. Okay. We'll do the second question since you're scared of the first question. What can I do if communication has been blocked by the mother exercising visitation? Things have been tense since I received custody of my child, and she's blocked my number from my son's phone as well as hers. I have no way of contacting my son when he goes to visit. What am I going to do to ensure he is safe and I get him back? I live in Smith County. She lives in Abilene, about 180 miles away. This has to stop. Not much better.
I know. Okay, so things have been tense. She's blocked his number. No way of contacting him. How old is the kid? Do we know?
We do not know. Make it up. You'll have to do that.
I love to do that. No, I'm going to go with like 9. Kiddo's 9 because he has a phone. So a 2-year-old should not have a phone. That's sound parenting advice there. Wait, does your son have your 2-year-old has had a phone?
I don't have a 2-year-old anymore.
She did.
She had an iPad, yes, but I think Casey got a phone at 3.
You're ridiculous. Ridiculous. So anyway, I'm going to go with 9. Kiddo's 9. What am I going to do to ensure he's safe and get him back? I kind of feel like he's
helicopter.
Yeah, helicopter / drama king. I mean, it sucks. So I'll say, all right, as far as communication is concerned, don't do that. Don't block the other parent from being able to communicate with you and communicate with the kiddo while you have the child in your possession. Okay. Now, I do understand that and I've had this happen in a bunch of my cases where the other parent every 2 to 3 hours is calling the kiddo and then getting the kiddo all riled up, and then it interferes with the other parent's period of possession. If it becomes a problem, then I get it, right? Even then, what I would encourage a parent to do is to say, okay, on Saturday at 7, I'm going to allow you to have visitation or electronic communication with the kiddo for 15 minutes just so you can be comfortable, right? I think that it pisses judges off when you have parents that are blocking and not communicating. So I just think that's not a good thing to do at all on either side. But ensuring his safety, you don't have to have access to him via telephone and to mom in order to make sure that he's safe, unless, I don't know, I'm presuming if she got standard visitation or got visitation, there was nothing for the court to believe that kiddo would be in danger. So sorry, I don't know. What do you say? What do you say to that? I don't know what you say. Yeah, I would, I don't know what to do about that. Sorry, you're just going to have to figure that out and be patient. And if she doesn't bring him back, that's why you have court orders. And so, that's the importance, and that's the significance of getting a final order or even a temporary order signed by a judge. Because if in fact it's signed and if the mother is not returning the kiddo, then you have the ability to hold her in contempt of court, which means she gets to go to jail for 6 months and she gets to pay a fine, or she gets to pay a fine of $500 per violation, and you get your attorney's fees paid back to you. So that's a contempt action. You could also request what we call a writ of attachment to basically say, hey, judge, she was supposed to bring this kiddo back this morning. She failed to do so. And so now I need you to go and have a sheriff's deputy pick up my child and bring him back to me because she's refusing to do so. So other than that, I mean, a lot of this stuff, you guys are just going to have to learn to trust the other parent. And it sucks. And I know it's probably difficult, but yeah, nothing else you can do about it.
So this is one of those issues that is frequently an issue, but should really never be an issue, right? I mean, parents should not have issues with the other parent talking to the child while they're in the possession. Like I said, unless it's, harassing, right? I mean, if it's a lot, but the kids should be free to call their other parent whenever they want to, right? Or whatever. A lot of times in court orders, we'll put in electronic communication provisions, right? To where we specify dates and times that the other party is allowed to communicate with the child, and the party that's in possession has to make the child available. I see the necessity for it. I just think it's one of those things that we should not have to micromanage and dictate from this side of things, right? I mean, parents should be able to co-parent enough to at least let them talk to one another. So you should have put that in your order, maybe next time. Considering electronic communication clause. I don't know, maybe this wasn't an issue before, we didn't anticipate it. I don't know, but yeah, it's rude.
I mean, I hate that. And so these are some of the things, like when clients call me and they complain about it happening, I kind of just say, there's really not a whole lot that I can do. And the things that I could do, they're going to be very expensive. And do you really want to incur that expense because she's blocked you? Now, what I would say is my advice in a case like this would be to document everything, right? And I would probably, if she still had the attorney, I would probably send that attorney a letter or an email. If she didn't have the attorney, I would probably send her something directly. I would have my client do the same thing, because obviously mom did something, and then for whatever reason the court felt that this kiddo needed to be with dad. And so if mom continues with these bad acts, then her visitation could go from a potentially standard possession order to something more restricted. And I've seen it and I've done it. And it's one of those things that as the mother, you need to be mindful to not be an ass and not alienate and not try to do this kind of crap just to stress dad out, because judges can say, listen, you're not acting in the kiddo's best interest, and so now I'm going to take some of your visitation away. But the key is documenting. And what I would also encourage this particular father to do is, when the shoe is on the other foot, don't do that to her, right? Don't block your phone. Leave the kiddo's phone open. Say, hey, mom, I know that this is tough on you, but feel free to call kiddo whenever you want to, or I'm setting up these days and times so you can talk to him. Because when you walk into that courtroom and you present the evidence of, look at how great I'm trying to do with co-parenting and how much access she has, and look at what she's doing to me, the judge is going to love you and not be so happy with her. But this whole idea of like, is he safe? If I'm going to bring it back, if you have concerns about your kiddo's safety, do a welfare check. But I'll say, when you do a welfare check, you better make damn sure that you have a legitimate cause for requesting that welfare check, because if you start doing that as a form of harassment, then you're going to have problems with the judge, and the police are not going to be very happy with you. And it's kind of like the boy who cried wolf, right? If you're calling in for, crap that's you should be calling in for, when you really need them, there could be some delay. So welfare checks are an option. Counseling for the kiddo is an option. If there's safety concerns, let's get them into counseling. And then the only other thing is get your order so you can hold her in contempt and chill out.
On the welfare check thing, right? I mean, you don't want to have to explain to your child while police are randomly coming to talk to him, right? Because you're afraid that he's in danger with his mom when nothing's really happening, right? And this is something we have to deal with a lot also, is people wanting to modify orders or get certain things in place based on the fact that they think something may happen, right? Unfortunately, usually something has to happen until you can make a move on it. I see both sides of it, right? You don't want to put your child in danger to where something's going to happen, but at the same time, the other parent's rights as a parent have to be protected, and you can't take those away just because you think something might happen, right? So if you don't have any evidence that he's in danger or that she's going to place him in danger, then you just got to roll until something happens, or like I say, get some evidence from counselor or on a welfare check or something like that, and then move forward. But good luck.
I mean, then that's always the most difficult part of these types of cases is, and I hate that, right? Like, I've had cases where the mom's like, listen, he, drinks all the time. Dad's an alcoholic and he drinks all the time. And I'm so worried that he's going to drink and drive and get in an accident when he has my kiddo, and something horrible is going to happen to my child. Then the question follows, well, has he ever done that? And sometimes the answer is, yes, and I was with him. Well, then how are you going to go in and argue because you were there and you permitted it? Or no, it never happened because I would always drive the vehicle. Then it's like, well, then dad didn't really put the kiddo in danger because you drove the vehicle. And so it's sheer speculation, it's anxiety. And I think it's definitely understandable that they have that anxiety, but the judge is not going to grant, any sort of restriction based on speculation, at least, not in my experience.
There is a presumption that parents will act in the best interest of their children. And so that's what courts go with unless you prove otherwise.
Right. And so, a lot of this stuff, and, I've had recent cases where, the mom in this case, 4 months. So kind of a similar situation. We were able to get primary conservatorship at the final hearing, and the mom 4 months was just committing bad acts and random things, right? Like not returning the kiddos, calling in welfare checks, CPS allegations, numerous CPS allegations, criminal allegations. And it was one of these things that I had to stay with my client and just encourage him and tell him, like, document, send, OFW messages, and let's just keep kind of putting all this stuff together. And eventually it's going to get bad enough where we're going to have to make a move. And it finally did. And when that happened, we had everything ready to go, everything documented, and it was just presented in a very seamless manner. And the judge was pissed at the mom, and she got restricted visitation. So some of these things you just have to kind of roll with the punches, and it sucks because kiddos are in the middle of it.
Well, what's a OFWA message? I think that's how you OFW. Is that how you spelled it? OFWA. What is that?
OFWA. I didn't spell it.
No, you spelled the word OFW. I'm trying to figure out how to say it. What is that kind of message? You said send an OFW message.
An Our Family Wizard message, Mr. Slide. Yes. Are you familiar with Our Family Wizard?
I'm not. Can you explain it to me, please?
I will. Absolutely. Not a problem. So Our Family Wizard is an app that you can download on your phone, on your computer, whatever. And it is a co-parenting app, Floyd. Is that the communication tool kind of?
management type thing. Yeah.
And so I want to say that it's like $125 a year. I feel like we should get some sort of sponsorship. Keon, get on this right now.
We need to get paid for this.
Exactly.
I'll even flash a brochure.
But each parent has to pay, it's like $125 a year, and they have the ability to message. All communication goes through OFW, and it even has this little like sensor on the keyboard where if you're angry typing, which Floyd, you angry type a lot, like your shit would be hot. Like all the time. But if you're typing and you're pissed when you're typing, it can sense that. If you like rewrite messages, I think it can sense that. But it's just a way for the courts and the parties to track all communication between the parties. And it's been super helpful. It's so helpful from the sense of people know that they're being watched, so they're not going to act like jerks, right? Because they know that it's, and sometimes they do act like jerks, and I don't understand it. But they do. And so when they do, we have that as evidence. And I don't know, I think in some cases it makes a lot of sense to have it. In others, and most, I would say it's really unfortunate that we have to have it, because parents should be able to just talk to each other and be freaking done with this. But it has a calendaring gap. It has a uninsured medical expenses reimbursement portion of it, which I love, because if you're sending bills to the mom and the dad, or the dad, and they're supposed to pay one half and they don't pay it when they're supposed to, it sets it up very nicely for us on an enforcement, and it eliminates a lot of the work that we have to do. So yeah, I mean, I think in a case like this, I would most certainly recommend that for my client. And there's also, I think, an app called App Close. Have you heard of that one before?
That's a free one, right?
Yeah, that one's free. It doesn't have as many features, but I think it gets the job done, equally well. So, yeah.
So I had a client using Our Family Wizard, and he told me he didn't like it because it kept telling him to consider rephrasing and wouldn't let him send the message. I'm like, well, you shouldn't be sending the damn message then. Like, that's the point of this.
Override.
Yeah.
No, thank you. People are so dumb. Well, and the other one, I had a case where the mother and father were ordered to use OFW, and then they had a parenting facilitator appointed. And so a parenting facilitator, like, that things have gone really, really bad if you have a parenting facilitator in on your case. But typically they are a counselor, and their sole job is to facilitate parenting between the two parents that can't seem to get along. And so in this one case that I had, the parents were going back and forth on OFW, and dad was just being just not a nice person at all. And so it was kind of cool because the parenting facilitator is kind of watching the communication. Then all of a sudden you see the message from the parenting facilitator just calling dad out and saying don't do this, right? So that's another thing that you can use is get a parenting facilitator. You can grant your attorneys access to it so we can monitor what's going on. It's pretty cool. I like it. Why did I go down that trail?
Well, because you used the word OFWA in your...
Did I say OFWA?
No, you said OFW.
Okay, go ahead.
Yeah, but even in when it's not a high conflict case, I like to use it for the calendaring and the reimbursement. Right? It's like a shared calendar. You put all the child's events on there, even if it's not high conflict, I amend the language that requires usage of it and only use the calendar. And
that's a good idea. Yeah, I don't know that I normally or I've ever done that, because I'm always like, the standard language when you use OFW is that the parents have to check it every 48 hours. If there's a request made and then you don't respond within the 48 hours, then you're waiving your response to it. All communication. So no texting, no calling, no nothing. All of that has to go through OFW unless there's an emergency. And so that's, like I said, that's the bad part about it, is that it's really, it's meant to enhance the parenting, but a lot of times it has this tendency of restricting it, because you guys can't just have a normal conversation like two parents should. But Yeah, I mean, that's a good idea. I might start doing that, my calendars and stuff.
You're gonna have to pay me for that then, because I came up with the idea. All
Every
right. So 20 minutes on that question. Hopefully we go quicker on the next one.
Okay, I'll ask the question.
It's a book, I think.
Yeah, okay. So where can I find an attorney to assist with this child support defense / father's rights case? Your favorite type of case.
Right here. Next question.
An ex-wife perjured herself in court to claim my friend had not signed away his parental rights years ago. She sought and was awarded back child support for the several years she had alienated the child from the ex-husband, who's my friend. The Texas AG has since threatened to take away his driver's license and professional licenses, and no one seems to care that this diagnosed mental health issues woman has committed fraud to pursue the claim. The family court judge just believed her without any evidence. The signed parental rights document from years ago is in the ex-husband's possession. Each family law attorney says he needs a civil attorney, and each civil attorney says he needs a family attorney.
All right. So we have friend. So is friend the same person as ex-husband?
Yes. So I should have rephrased this to say, mom requested back child support for several years. She had alienated the child from dad. AG's threatening to take dad's licenses away from him. Mom has diagnosed mental health issues, and that's why she lied about it. And the family court judge believed mom without any evidence, including the fact that the dad had signed a voluntary relinquishment. And I guess dad doesn't have it in his possession. It's in ex-husband's possession.
Ex-husband's not dad.
I don't think so. Yeah.
Okay.
Clearly, it would have been offered into evidence if he had it.
Okay. This is another one of those where you're screwed. So we'll start with the first sentence, right? So he signed an affidavit of voluntary relinquishment. Doesn't matter. If his rights were never terminated, he still has child support obligation. You can't just sign away your rights without the other party agreeing to it. So still have child support obligation. She was awarded back child support for several years when she alienated the child from the ex-husband, which is also the friend. They are the same person. It says ex-husband, parentheses, my friend. Okay. So I'm assuming ex-husband / friend didn't show up to court.
/dad.
/dad. Okay. Didn't show up to court to defend the suit. So if he was appropriately served and everything was appropriately pled and he failed to file a response within the appropriate time, and at the prove-up hearing, all of the appropriate evidence was admitted and the order was drafted appropriately, there's nothing you can do about it.
So let's just say, hypothetically speaking,
Of
course, I'm going to make up the facts here. Dad did show up with the affidavit of voluntary relinquishment.
I don't care.
What?
Doesn't matter if he voluntarily relinquished. You can't voluntarily relinquish your rights. Like, they have to be terminated before you lose your child support obligation. You can voluntarily relinquish, but mom doesn't have to accept it.
But what if there's also this argument of parental alienation? And so what if mom told him, 7 years ago, I don't want you to have anything to do with my son, sign this affidavit, I'm going to terminate your rights. And so that's why he did it.
I still think if he failed to respond to the suit,
objection is to non-responsive.
Question.
My question was if he had shown up with it.
Oh, gotcha.
Okay, so dad shows up to court. He has the affidavit of voluntary relinquishment. And he says, Judge, I relinquished my rights because she told me that I needed to get the hell out of this kid's life. And so that's why I haven't paid child support, because that's what she wanted.
Yeah. So at that point, the judge could order retroactive support if he wanted to, but I think it depends on the judge and the amount of the evidence. If she's communicating anything with him before now, I think for the most part, judges probably would not order retroactive in that case.
Yeah, I don't either. And so I actually have kind of a similar thing going where the mom when the child was born told my client that it could be the father, he could be the father, but it could also be like 2 or 3 other guys. And so, and basically, I guess she ended up getting with one of the other men and marrying that other man eventually. And then at some point did a DNA test with that other man, and it turned out that he's not the father. And so like 10
other
years,
man or your guy?
The other guy, the husband is not the father. And so then she's filed a case against our guy requesting retroactive support and current support, etc. And so, and thankfully, this guy and his family, they had saved a lot of the messages from when all of this stuff was going down, where mom was like, not your kid, not your problem. My husband's taking care of him, whatever. And so I think that I have a pretty good shot of not getting any retro support for this kiddo.
So does that even matter really for the first 4 years of retro? I thought the question of whether they were aware of the child only comes up if you try to seek retroactive support more than 4 years out.
No, even for the 4 years. So the presumption is, I guess let's go back to that. So with the retroactive support claim, and so basically what that means is that dad or mom hasn't paid any child support. I guess it couldn't be mom, because mom would know that the baby was hers. So
you never know.
Maybe for dads. So retroactive support is basically when they haven't paid any child support, and then you're getting into court years down the road. There is a code provision that said it is presumed to be in the best interest of the child for the court to grant 4 years worth of retro support. Are you pulling up the code, Floyd?
Yep.
Okay. And so I think that's the presumption is like, yeah, that needs to happen if dad hasn't paid child support. But you can rebut the presumption, and you could basically say, look, Judge, I know that this is what the code says is presumed to be in my kiddo's best interest, but here's the reasons why you shouldn't grant that. Right. And so, and you can work the presumption both ways. Right. So I had a case that I was requesting retro support for 14 years because the dad had done this goofy stuff where he let the mom and the kiddo live in the house, and then but it was his house that he owned, and he was paying the mortgage down on that house and then letting the mom and the kiddo stay in the house. And then he comes back 15 years later when mom decides that $750 is not enough for her current child support. She comes back and she says, I want to increase my child support. And then dad kicks her and the kiddo out of the house and basically says, well, I paid her all this money over the past 15 years. I shouldn't have to pay her anything. And my argument was, well, no, you were paying yourself, right? And my client didn't get any benefit of it. And so we got the whole 15 years of retro support. That was a nice little payday for Our Lady.
I need one of those.
Yeah. But presumption can work both ways, right? They were arguing it should only be 4 years, and I was saying, nope, should be more. So
it says that. So it says that it is presumed that a court order limiting the amount of retroactive support should not exceed total amount due for 4 years. Sorry. And then it says the presumption created under this section can be rebutted by showing that the obligor knew he was the father or he sought to avoid the establishment of child support order. So that rebuts the 4-year presumption, right?
Mm-hmm.
But I don't get out of that you can challenge the first 4 years.
What do you mean?
So it says it's presumed that they should limit it to 4 years. Okay. But I don't see that the presumption is they should order 4 years. This isn't making sense at all. Okay, so you have the 4 years, and then you have the more than 4 years over here, right?
Okay.
Yeah.
Got it.
So it's presumed that they should only get this, not this, right?
Can you not do that, please? Okay, I got you.
But can this
Uh-huh.
be taken to this?
I think so. I think, Floyd, how many cases have we had where they haven't ordered any retroactive support at all? Because the mom didn't file the case, because the mom didn't know who the dad was, because the dad had no idea that he was in fact the dad, because the mom was keeping the kiddo away from the dad. I don't think it's an automatic 4 years. I think you've lost your freaking mind. It is Friday. It's been a long week. I'm going to let you pass. I'm going to let you slide on that one.
Yeah. Okay. I don't know.
Thing, but I don't think it's a for sure, like, you get your 4 years. No way, no how.
Yes, I do think it's discretionary, but I don't think there's a presumption that it has to be rebutted. I was looking to see what a burden would be to say no retroactive, right? That's what I was trying to figure out. And I don't see anything.
Okay. Perhaps we research this another day.
Now let's go on.
Okay. And I guess that's a good thing for us to kind of mention. Like a lot of this stuff, most of the stuff,
Yeah, most of it probably.
most of the stuff, we have to go back in when we're actually working our cases and prepping our cases. We are looking this stuff up. We're researching the codes or researching the case law. We're refreshing our memory. We have detailed notes when we're going into the courtroom for our arguments to the court. Like, you know, it's the study and the practice of law. It's a lot of crap that lawyers have to know. Now, good thing is that we've been doing it for so long that we kind of know somewhere way back here that something somewhere said that this was the law, and so we go and we find it. But just be mindful of that. Some of this stuff we have to research, and this is gonna, I guess, maybe be one of those things. So anyway, too late to ask for, oh, your turn?
Yeah, if you don't mind me getting involved here.
Proceed.
Thank you. Since you win, it's now presumed that it's my turn.
Okay, excellent. You rebut the presumption?
You cannot rebut the presumption.
Okay.
It's unrebuttable.
Go ahead.
Too late.
Take it too far. Like it was good. We were good. And then you just stretch it.
Why? What was wrong with unrebuttable?
Go ahead. Just go.
Is that a word? I don't know. Okay. So too late to ask for a motion for leave to amend. I was not prepared to present evidence properly. That's because you didn't hire an attorney and was unable to have it heard by the court. The entry of the order, the judge has asked us to draft it. Can I start over?
Yeah.
Okay. The entry of the order the judge has asked us to draft is due in 3 weeks. Is it too late for me to ask for a motion to leave and amend my original petition? Or can I even do that at all in this case? Nope.
You're toast. Meld the toast. So that's a thing.
Smell the toast.
I don't know. I think it's a thing. I don't know what it is, but I'm going to go with it. So did you know that that you can request or file a motion to reopen evidence?
C.
Okay. But it has to be done prior to rendition of the judgment, right?
I just know that you can do it. If that case came to me, I would have to research how.
Right.
But I have heard of it.
So I've had an issue like this come up before, and I think based on what I can recall from way back here, is that it has to be prior to rendition of judgment. And so in that particular case, we had finished up the evidence, and a lot of times the judges will say, I'm going to take this under advisement. And basically what that means is the judge needs to think about it before he tells everybody what he's going to do. And so in that particular case, he was going to take the case under advisement. And then there was some potential evidence that we wanted to proffer that we had just learned about. And so we considered filing a motion to reopen. I don't think that we actually did, because we got the ruling back and it was favorable, so we were done. But you can do that. I'm almost 100% sure it has to be done prior to rendition. So no, you can't ask for leave to amend your petition, because that has to be done no later than 7 days prior to your final hearing. Or you can do a, what's it called when you do it?
Trial amendment.
Yes, you can do a trial amendment, but it cannot operate as a surprise to the other side. And so obviously you never want to put yourself in that position if that can be avoided. And so no, you're toast.
So why don't we explain a little about what reopening the evidence means? So typically when you have a hearing, and I guess on TV, you'll see petitioner do an opening and then respondent do an opening, sometimes unless they're reserved. And then petitioner puts on evidence, they rest their case, and then the defendant puts on their, or respondent, whatever it is, puts on their evidence and they rest their case. And then respondent will close, which means I'm closing my evidence. I can't put on any more evidence. And if for some reason the respondent didn't close and put on additional evidence, the petitioner would have to reopen their side because they already closed their evidence. Or if both parties closed, like in your situation, then prior to judgment being rendered, they could ask the court, hey, can I put on more evidence, please? I forgot something. Most of the time, the judge will say, no, you've used up your time. I don't want to hear anything else from you, Ms. Jimenez, because they don't like to hear her talk. But somebody like me that's enjoyable to listen to, they will probably allow me to reopen.
Right.
Opinion.
So he can't file, I mean, maybe he could try to file a motion for new trial, but if he was there and he just screwed up on the evidence, it's highly unlikely that that's going to happen. And so.
But he's asking for more than just to reopen, right? He's asking to completely amend his pleadings after all of the evidence has come out, to, I assume, request something new. Yeah. Not a shot in hell, buddy.
So I was actually talking to an attorney about this yesterday. It is so very important that when you have a hearing, and I would even say temporary hearings are more important than the final hearings. And a lot of attorneys will tell you, oh, this is just a temporary, don't worry, we'll address it at final and we'll put on everything at the final, not a big deal. I 100% disagree with that. I think that your temporary hearings, you should be preparing for them like they are final trials, because what happens at a temporary hearing is more than likely going to happen at a final hearing. And so when we roll in there for temporary, we are ready to rock and roll. And so, and obviously for final trials, I mean, equally as important, but you need to make sure that all of your pleadings are correct. You need to make sure that all of your exhibits are ready, they're admissible. And if there's any potential, problems that you could have with a piece of evidence, you better have a legal argument to back you up. You have to be ready, because in most of these cases, these judges are just slammed on their docket they're not going to give you time. They're not going to be patient with you because you didn't have your crap together. They're not going to, in all cases, reset it because you didn't file your correct pleadings. And then you end up in the situation like this poor person that you're screwed. There's nothing that you can do about it. You have to wait for modification depending on what happened. If it's a kiddo, then you have to modify in the future. And if it's a property division, I mean, you're done. You're absolutely done. I had a case several years ago where there was a claim for a separate property home, and it was on the other side, like the attorney on the other side had the separate property home, and he showed up, and that's a clear and convincing evidence standard. And he showed up with nothing to prove that it was the separate property home of the husband other than the husband's testimony. And in that case, his client lost $150,000 that he should not have lost. And so you got to be ready for this stuff, and you have to hire a lawyer. Why is it that everybody thinks that they can do family law? Have you noticed that?
Yeah, I guess they think just because they can argue, they can practice law. Yeah, I don't know.
They don't try to do like bankruptcy. They don't try to do like immigration. But when it comes to divorces, they think that it can just be done. I feel like my role in this world has been minimized.
Well, I think maybe because I'm so good at it, I make it look easy, right? And so people that are watching think, oh, that's a piece of cake.
Maybe that's what it is, like, maybe. But don't represent yourself. Don't do it. And I don't care if you're a lawyer, don't represent yourself, because it's a recipe for freaking disaster. And there's no take backs in some of this stuff. So.
And the chances of you winning are pretty slim, because believe it or not, what we do is reasonably difficult.
Yeah. Especially you have a tendency of making things way more difficult than what they really should be.
I like to think of it as identifying issues others wouldn't spot.
Okay, you do you, boo. You do you. Okay, next question. My turn to read or your turn?
It is your turn.
Okay. What can I do for my second daughter whose dad never signed the birth certificate and passed away before attending the child support court hearing? Can paternity still be determined? Oh, this is a good one. Can paternity still be determined now, or is there not anything else that I can do for my daughters? I was also advised to apply for survivor benefits for them because they are still so young. I just feel bad for my girls.
Interesting.
I know. Have we ever had a case like this?
This is one of those cases I'd have to research. So I feel like it's going to depend on how long he passed away. Like, this is just for everybody watching. I have no idea what I'm talking about. I'm completely going off a gut on this, but
so you're one of those people that thinks that you can practice family law and you don't really know.
Exactly. Yeah. For purposes of this question, pretend I'm not licensed. So I feel like that if you got him before he's buried, you could probably get a blood draw authorized. Probably would not get a judge to exhume the body from the ground to do the blood.
Floyd,
zero basis for that.
Isn't there a way that you can do genetic testing of family members?
I'm also not licensed in genetic testing.
Okay. So I think that I've read someplace that you can petition and request like family members, and that is potentially a way to do that.
Okay.
Yeah, and I don't know enough about genetic testing to be able to say like the sisters, if they're sisters, like how all of that would connect. But there has to be a way like that. This has probably happened a million times. Are you looking it up?
Mm-hmm.
Okay. So there has to be a way to identify this. And
so it says that Texas law provides that the court may consider the results of genetic testing of the man's parents, man's brothers or sisters, or any other of the man's children, or the man's relatives necessary to complete genetic testing.
I'm so good.
I knew it.
Or you could exhume the body.
No, I said they wouldn't exhume the body.
Oh, okay, Floyd. But that's where you were going.
Yeah. I'm not for pulling up dead folk.
Oh my God. So yeah, I think there's a way to get that court order, and then you establish the parentage, and then so there's the survivor's benefits from Social Security that you may be able to obtain. But that's actually interesting. Also, something that I've never done before is Maria says that there is genetic testing for family members, and she personally knows someone that was the dad's sister and was tested. There you go. So now you know, Floyd.
That on Facebook.
Look again, Floyd. So
it's not working.
You can go, and if somebody passes and they leave money behind, so they have an estate, right? The house, bank accounts, life insurance policies, etc. If they pass away, you can go after their estate to be able to collect any child support that you would have otherwise been entitled to for the remainder of the kiddos' lives. And so we've never had a case like that before, but it is something that you can do. And so if you find yourself like this young lady here, may need to look into that and see if dad left any money behind, because kiddos are expensive. They're so freaking expensive. And so, yeah, I would look into that as well.
What if the money under the will has already been distributed to the other heirs? Can she recover?
So I would say if she has a daughter, she has his daughter, she would have the right to notice. And again, we don't practice probate law either. So we really have no idea what we're talking about with this question.
Well, but so we're just completely going off with him. But so the executor or executrix, if you will, would not know he had a daughter, right? Because we're waiting on genetic testing.
Well, he had another daughter in this case. So he had two daughters, one that was established, one that wasn't. So, but assuming that he didn't have any daughters at all legally that he knew of, that the executor would have known of.
Or executrix.
Or the executrix.
I love that word.
So, yeah, so no notice.
Yeah, also not the question. You want to go on to family law?
Maybe we'll know a little bit about that.
We just made ourselves look stupid.
Okay, moving on. My turn.
I lived long enough not hearing executrix.
That's Chandler's new word.
You're going to law school, buddy. You're about to hear it.
Exactly. 1L year, all over. So can I use my divorced husband's last name for a child, not his, and born a year after divorce? My ex-husband. Keon with these questions.
Is this a full moon or what?
Oh my God. So my ex-husband doesn't want the child carrying his last name because it isn't his.
No shit.
Next question. That's our legal advice. No shit.
I think you can name your child whatever you want. Right? I think it's weird. But my opinion doesn't really matter. But I think you can name your child whatever you want.
Yeah, on the birth certificate or you just put what you want, huh?
Yeah. I wonder how many people have named their children after me just so they would have my last name. Probably a lot.
Yeah, that's kind of scary, but we might not want to advertise. So, yeah, I mean, you can do that. Could the husband or ex-husband file a request to change the child's name? He wouldn't have standing to do that.
Yeah, you can't do shit.
Oh my gosh, dude. Why? Maybe they have kids together, and
yes.
So he wants that all the kids to have the same last name.
Yes. Yes, obviously. I mean, do you think she was that creepy?
I don't know, dude. There's some people that are pretty creepy out there. Maybe. Okay. I'm gonna try to find a question that we might know the answer to.
Keon, bud, we gotta get something going.
I mean, these are all pretty, yeah, we have another change of last name, so that's easy.
Service members affidavit. You talk about that. If you know about service, I guess.
So you service members affidavit, not service.
Well, but it's associated with service.
Is it? Well, let's teach me, Floyd. Go on ahead.
Well, so service member, the first part of that is service.
Uh-huh.
So
That's
service.
I don't think that that's what they're talking about, Floyd.
No. So a service member's affidavit is just an affidavit you submit to the court stating that on a default, you would do it to state that the person is not in the service, actively deployed and all that kind of stuff before the court would let you default. It's also done. There's another instance where it's done where you're saying that the fact that I'm in the service had no impact on my agreement. Is it in voluntary relinquishments? It says if I am in service, then it had no impact on my decision.
Yeah.
Yeah. So, but in this case, service member's affidavit with regard to divorce. So a person has a right to notice of the petition that you file, i.e. service, not the service member, but the service, unless the person is a service member that you want to serve.
Your
right?
hands are like out of control today, dude.
Yeah,
like but go ahead. Yes, you're right.
So it's called service when you deliver a copy of your pleading to the other party. And so they have the right to be served with a copy of those pleadings. And so if the person is served and they are a service member, i.e. in the military, then it may impact their ability to respond or answer. And so if a person fails to respond, then you can move forward with a default, basically get whatever you want. And so you have to submit the affidavit so the court knows that I'm not defaulting a service member that was incapable of responding. So yeah, so I think it is related to service.
It is. I withdraw my previous smartass remark.
What about your 10 previous smartass remarks?
No, those were all valid. 10 is a good question. How to divide my house in a divorce?
Chainsaw.
I bought my house in 2003, got married in 2007, was divorced in 2022. We paid for our house in 21. How much does my ex get from the house?
Karina, go. She doesn't tell us what it's worth. How are we supposed to know how much?
I'm going to say, don't worry, I have it covered. The house is valued at $400,000. And at the time that they got married, she had already paid $100,000.
I think he'll get approximately 39%.
Why would you do it that way? Why wouldn't you just say $150,000?
You don't know what the house is worth.
I said it's worth $400,000.
You're making shit up. I'm telling you, I don't care what the house is worth. He gets 39%.
And
but
how
let's see if it works. So you said 400,000.
Mm-hmm.
So how much would he get?
So she had paid off $100,000 at the time of the marriage.
So you get 150.
Yes.
Right?
Yes.
39% is 156,000.
So good, Floyd. And so hold on though. No, you're wrong. What are you doing? You're confusing. Why do you complicate everything? It's a reimbursement claim. Okay, so let's back up. I'm going to walk through it and then you're going to be right and I'm going to be pissed, but I'm still going to walk through it. Are you recording this?
No. Since you're sitting down, I'm going to stand up.
Okay, you do. Oh, you're all fancy now with your little desk. So, okay. The house is wife's separate property because she bought the house before they got married, which means that husband cannot take the house away from her at all, period, because it was hers before they got married. So what the husband is going to be eligible to receive is something that we call a reimbursement claim. Okay. And there's different ways that you can establish a reimbursement claim. The most common is a reduction in the principal balance of the mortgage during the marriage. Okay. And the way that it works is, so in this particular case, they owed $300,000 at the time that they got married. And so during their marriage, they paid off $300,000 towards the principal balance of that note. Now, everybody knows that you're going to pay more than the $300,000, right? Because we have taxes, we have insurance, we have interest, we have all that crap. That doesn't matter for the purposes of a reimbursement claim. The only thing that the court is going to be concerned about is how did you or what did you reduce the principal balance by? And so in this particular case, they paid off $300,000. So what that means is that wife's separate estate is going to owe the community estate, which is comprised of husband and wife, $300,000. And so in that particular example, husband would be eligible to receive $150,000 as a reimbursement claim to the wife or from the wife's separate property. Now, the way that husband gets that, most of the time what we try to do is we try to say, okay, we have this retirement account and wife's supposed to get 150 and you're supposed to get 150. So now, husband, we're just going to give you all of that retirement account and then we're clear on the reimbursement claim. But what could happen and what sometimes does happen is that there's not enough money to cover the reimbursement claim. And so then what happens is husband gets a lien on the house for 150 grand and yes, it got more.
Yeah, so I basically did the same thing. I said, yeah, so assume forgetting about interest and all that, she paid a total of 18 years, 14 years of it was during the marriage, which is 79%. You divide that in half.
But you're up the 400,000. Because you said it depended on the value of the home. The value of the home doesn't matter. Because even if when they bought it, they paid off, they got 400 grand. If the house is worth like 800,000 now, reimbursement claim still only 150. The other thing that we see a lot of, which drives me freaking nuts, is let's say hypothetically speaking, wife bought this house and then during the marriage, husband puts a new air conditioning system in the house and fixes the, bathroom tile and, adds a porch to the backyard. And it took, 50 grand for them to do all of that craziness. You don't get the 50 grand back. What you get is, what you have to show is that the renovations that you completed in the home actually increase the value of the home. And that's just so hard to do because you have like the market going up, you have all of these added benefits. And so that's almost an impossibility.
True that.
Okay. So you were wrong. This is what I gathered. You're the only.
No. I was talking about the principal balance.
No, you weren't, Floyd. Why do you struggle with admitting when you're wrong? This is a growth opportunity for you, Mr. Floyd.
Never wrong. I would admit it if I was wrong.
Right. Okay. So like we say, beginning, middle, and end of this event, please do not construe this as legal advice because as you can tell, some of the stuff we still would have to research while we're talking about it. And your facts and your scenarios, everything that you're going through could negatively, or not negatively, they could impact what our opinion is on a particular fact pattern.
It
And
could be negatively.
it could definitely be negative. It could also be positive. And so what I would encourage you all to do is, if you find yourself in this situation, please go and visit a family law attorney and listen to their advice, and make sure that you do actually go out there and hire an attorney, because as you can see, not doing so can have devastating consequences. And also, again, Twitter, Facebook, Instagram, TikTok, all that good stuff. Please like and follow. We greatly appreciate it. And we will see you next Friday.
Toodles.
Toodles.